And we are back. And we are back. So I wanted to be able to share that information with you because many times, people just don't know what the law is, and as a result, they're able to make mistakes because they don't know what they're supposed to do. You know what I'm saying? And we do know that guns, are dangerous in our society. You know what I'm saying? We know that. And we know that no matter what, guns don't need to be on these streets. However, it's my opinion that you cannot use pretextual reasons in order to take those guns off the street. Now, speaking of guns and what they can potentially do, let's talk about what's going on in Michigan in the Oxford case. Well, those of you all know that Ethan Crumley has been charged in a mass murder of several students at Oxford School. Now, I'm going to be honest. Okay, see, this is why you can't be no backseat quarterback, because it's dangerous. Okay, so I was like, why would the attorney waive the exam in this particular matter? Hold the exam, see what problems the exam has, what witnesses, what they don't have, etc. Now, his defense attorney, she might be not having that long, but working, she's smart as a whip. Because reason why she waived the exam is very brilliant. Simple. We're not disputing that this happened. We're not disputing that Ethan shot these people. We're not disputing that they died as a result of him being shot. We're not disputing any of that. What we're saying is that at the time that he committed this act, he was not sane. He's filed an insanity defense. What is an insanity defense? Basically, it is what they did this week was it was a notice. Hey, judge. Hey, prosecutor. We're not disagreeing that these people were killed or shot, but we're saying that the reason at the time that this occurred, we believe that there's evidence to show that their client, Ethan Crumley, was not mentally able to form the requisite intent to commit those crimes. Now, let me get to that because I'm trying to, and I know y'all smart. There's the act, that's this cup, and then this lip gloss is the intent. The prosecution must show that when the defendant or person charged did the act, he had the intent. They got to go together. You have to show the act and the intent. If you have the act without the intent, then they have not proven each and every element beyond a reasonable doubt. So what the allegation now is, well, yes, we don't dispute that there was a shooting, but he was not mentally able to form the intent to kill, as you have to have for premeditation, or to commit great bodily harm, or to commit, or to have any of the intents necessary for murder, because at the time of the action, what occurred in Oxford, he was insane. Now, what they do now is they send a notice, and they have to probably do it 30 days before trial. So this was far off. Now, Now the prosecution says, okay, we know where you're going. You're not saying, oh, it wasn't him. Like many times identification is an issue, but that he didn't have the intent. And so one of the things that the media has indicated is that he was saying that he was hearing voices. There was an issue with a dead bird. He was what the defense is alleging, and I believe that they believe they may be able to substantiate that he was having a meltdown at the time that this occurred. And if so, the law says that you can only prosecute someone if they were acting under the necessary mental, what we call mens rea. It's mens rea, which is mental, and actus rea, which is the act. So how do they do that? Well, they're going to refer him to the forensic center. And at the forensic center, they will do an evaluation, competency, to determine whether or not he understood what, he can assist in his defense, as well as if during that time he was able to understand the rightfulness or wrongfulness of his conduct. So if he thought that when he pulled the gun out, it was a broom, okay, and they can say, well, based on the type of tests that we've given, our interview, assessment, we do not believe that he was understanding what he was doing at that time mentally. Then the prosecution can ask for what we call an independent. What is an independent? Well, let me tell you what an independent is. An independent psychologist is somebody who they use to assess whether or not he was insane at the time that he committed this crime. So what you have potentially is one expert saying, yes, he was, and one expert saying, no, he wasn't. And then they battle. Now, what is an insanity defense? A defense is something that you present if believed. You don't have to believe a defense. So what can happen is these experts can be presented at the trial because it's a defense. And a defense is a bar to a crime if you believe the defense. If you believe that I was scared and I acted in self-defense, then despite the fact that I killed somebody, it's excused. Okay? So it's a defense if believed by the judge or jury, whomever is a trier of fact. So in this situation, they will present the experts at a trial, okay, in front of the judge or jury. And they will determine if they have an expert that says, yes, he was insane, and no, he was not. Then they'll listen to those experts, and those experts can be able to say, well, yes, we believe this person, or no, we don't believe this person. It's very complex. It's very lengthy because right now, in order to get an evaluation in the forensic center, I know when I was a judge, it was about 3 months. With COVID, it's going to be about 6 or 9 months. Then once they get the evaluation back, they're not stuck with it. They can say, well, we want an independent. And what an independent is basically an expert that you feel comfortable with, that has the expertise, and basically is going to testify to what you believe that, you want them to say, because they're an expert for you. And so then it becomes extremely protracted. And we'll talk about that and more when we come back. We got to take a commercial. We'll be back.